we do have another article from the Federalist. We have the Supreme Court of America agrees presidents have the immunity from criminal prosecutions, but to what degree do they have it? The Supreme Court heard arguments on Thursday morning in the case of Trump v. United States on the question of whether and to what extent a former president of the United States enjoys immunity from criminal prosecutions for official acts while in office. Most of the justices seemed dubious about both parties' positions in the complex and largely uncharted area of law. No statute, prior Supreme Court precedent, or provision of the Constitution speaks directly on this issue. In 1982, the Supreme Court in Nixon versus Fitzgerald ruled that the presidents enjoy immunity from civil legislation based on their official acts. The court, in a 5-4 ruling, grounded the immunity in the Constitution's separation of powers. It reasoned that it would be inappropriate for the judicial branch to inquire into the reasons for presidential decisions for purposes of holding the president personally liable for damages. The court emphasized the unique nature of the responsibilities of the president in arriving at this conclusion. In Trump's case, the parties and the justices all agreed that in certain points, first, that purely private conduct by the president, which allegedly criminal, could be prosecuted. Trump's lawyer also conceded that campaign conduct, acting like an office seeker rather than an office holder, was private rather than official conduct. Second, the president had some constitutional powers that are exclusive to the presidency, such as the power to grant pardons, and therefore acts carrying out these powers simply cannot be criminalized by Congress or prosecuted by prosecutors. These were referred to as core areas of presidential power throughout the argument. Beyond these 2 points, the parties and the justices widely diverged to their views from the applicable non-mementure to the scope of immunity to their predecessorial mechanisms for implementing it in the courts. Technically, the question before the court is whether, and if so, to what extent does a president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. Trump's lawyer, John Sawyer, urged the justices to find that former presidents enjoy immunity from criminal prosecution in the same way that the earlier Fitzgerald case applied to civil cases. That ruling would preclude criminal prosecution for any act that came within the outer perimeter and the scope of president's official acts, regardless of the reason, motive, intent, purpose, etc. for taking those acts. Sawyer argued that the objective analysis should be used by the courts to determine if the conduct was or was not within the scope of the official responsibilities of the president. In other words, the analysis depends on whether the president's actions could be conveniently have been within the scope of the authority and not on what the president actually had in mind. Okay, so I can kind of see where they're going with this, but at the same exact time, are you really going to sit here and say that spilling the beans on some documents is within the rights of the presidency? I don't really agree that it is, but at the same exact time here, we can also look at all the other presidents in history and we can see that they did the same exact thing, if not similar things to what Trump did, and they're not prosecuted. So are we going to sit here, try to prosecute all of the other people, but then we're going to sit here and say there was a consensus to not prosecute your political rivals? Okay, so why are we doing it? Why are we doing it then? If there was a consensus not to prosecute your political rivals, because by the looks of it, Trump is getting prosecuted, in which he's there. He's in court every single day, supposedly falling asleep. So are we going to sit here and say, well, there's a president to be had? No, there's not a president to be had because Hillary Clinton's email server got leaked. We didn't prosecute her. We had other presidents that kept their official documents in old buildings that used to be bowling alleys. But that's not bad. We have Obama taking all of his official documents and putting it in the official library. That's not bad. No, that's not bad. But it's bad when Trump does it.